Madam Speaker, excuse me. One of the things that we've heard repeated a number of times, the gentleman from Rhode Island suggested it, the gentlewoman from Washington just said it, that if you go to arbitration, the company picks the arbitrators, and that's it. That's not, in fact, correct. Courts police the fundamental fairness of the arbitration process. If there is a process that is fundamentally unfair, the courts will modify it until it is fair. So that's a misconception. Furthermore, it's also been suggested that you never have any opportunity to have it, that it's by the whim of the arbitrator what the result is. That's exactly what Mr. Cicilline, I believe, said. That also is erroneous. If an arbitrator writes an award, a decision that manifests a disregard of the governing law, like the soldier who had been in arbitration for 8 years that he suggested, the courts will strike down that arbitration award. Yet it's important to know those premises before you decide what you do on this bill. And with that, Madam Speaker, I would yield 2 minutes to the gentleman from Wisconsin, Mr. Fitzgerald.
The gentleman is recognized.
Madam Speaker, I rise in opposition to H.R. 963. H.R. 963 undermines freedom of contract as well as consumer choice by banning informed, consenting adults from freely entering into contracts to arbitrate disputes. Arbitration generally works well and is a fair and effective way to resolve disputes. While civil litigation can be long, complex, and costly, arbitration provides a cheaper and efficient process to resolve disputes in a timely manner. Banning pre-dispute arbitration agreements will mean Americans spend more time in court with no guarantee of better outcomes. Banning arbitration agreements during a time of significant inflation and in the middle of a supply chain crisis will effectively lower Americans' income. While larger companies may be able to deal with the expense of a slew of new lawsuits, this change will cause harm to smaller businesses that may not survive lengthy and costly litigation battles. Because post-dispute arbitrations are rare, banning arbitration agreements will flood the court system. For one thing, some claims that are addressed through arbitration now may be individualized, making them unsuitable for class treatment. Even where claims can't be combined, a plaintiff may still be worse off as a class member than he would be with the claim in arbitration. This is because the benefits of arbitration, particularly lower litigation costs, coincide with lower revenue for others, such as trial lawyers. Banning certain pre-dispute arbitration clauses and similar policy will benefit trial lawyers, not necessarily consumers. I urge my colleagues to oppose this legislation, and I yield back.
The gentleman reserves.